Welcome to CLIP, a law student organization at the Sandra Day O'Connor College of Law at ASU that is dedicated to providing the public with useful and digestible legal information. Please note that CLIP-produced material is not meant to substitute for legal advice. There's a lot of information out there about operating a business during the COVID-19 pandemic. Legislation, regulations, proclamations, executive orders, and administrative guidance have been issued at each level of government. We read them all so you don't have to. This clip is intended to help you understand which recommended and required practices apply to your specific establishment. Information is current as of July 31st, 2020. Please check the resources linked at the end of the clip for the latest information. Maricopa County requires all patrons and staff to wear face masks while in places open to the public. There are exceptions when one is in a personal vehicle, personal office, or other private space. And of course, restaurant patrons may remove their masks while seated at their tables to eat and drink. Public events with more than 50 people are prohibited. The operation of indoor gyms, movie theaters, and water parks is paused, as well as the operation of bars with Series 6 or 7 liquor licenses, although pickup, delivery, and drive-through services are still allowed at these establishments. Failure to comply may result in the suspension of any license the business holds. All Arizona restaurants must reduce capacity to less than 50% of the permitted fire code and ensure at least 6 feet of separation between indoor and outdoor tables and waiting areas, unless tables are separated by plexiglass. Failure to comply with this order may result in the immediate closure of the facility. Don't forget, Governor Ducey's May 26 executive order is still in effect. It legally requires businesses open to the public to implement policies based on guidance from the CDC, OSHA, and ADHS. Employers may require employees to wear protective gear such as masks and gloves and implement social distancing, but they are not required to provide masks and gloves to their staff. Employers should grant reasonable disability or religious accommodations at employees' request if feasible and not an undue hardship on the operation of the business. Employees can be discharged if they refuse to wear a mask or take safety precautions. If a patron refuses to wear a mask or follow safety procedures, a business may refuse service and ask them to leave or contact law enforcement if they refuse to leave. If a business continually fails to enforce the mask requirement among its patrons and staff, it may face civil penalties. Employers are not required to permit employees to work remotely. If an employee has a disability under the ADA that puts them at a high risk for COVID-19, they may be entitled to work remotely as an accommodation upon request if it is reasonable under the circumstances. Employers are required by law to provide a safe and healthy workplace. Accordingly, employees have the right to file a complaint with ADOSH if they believe their employer is not taking appropriate steps to protect them from COVID-19. If an employee refuses to work because they feel the workplace is unsafe, and the employer has made a reasonable effort to adhere to governmental requirements and guidance, the employee may be discharged. However, an employer may not discharge or otherwise retaliate against an employee for raising concerns about the safety of the workplace. Employers may inquire about symptoms associated with COVID-19, require employees to stay home if they have symptoms, require a doctor's note certifying that an employee may return to work, take the body temperature of employees, and require COVID-19 viral testing. However, employees may not require antibody testing as a condition of returning to work. If an employee tests positive for COVID-19, it should follow the extensive CDC guidance linked here. All related health information must remain confidential. Employers are not required to notify other employees if one of them tests positive. However, employers may disclose the name of an employee who tested positive to a public health agency. Employers may be required to grant reasonable accommodations if an employee is at higher risk of complications from COVID-19 due to a disability recognized under the ADA. Employers are not required to accommodate employees who seek accommodation just because a family or household member is at higher risk due to a disability. Employees aged 65 and older do not necessarily have the right to reasonable accommodations based on their age alone, although employers are free to provide them. Employers may not require employees to stay home against their will simply because they are age 65 or older, even if it is with the intention to protect them from COVID-19. Employers may not fire employees simply for testing positive for COVID-19 or for having underlying conditions vulnerable to the virus. In addition to contracted sick leave, employees must receive up to 2 weeks of paid sick leave while the employee is quarantined or showing COVID-19 symptoms. An employer must provide 2 weeks of additional paid sick leave at 2/3 the regular rate of pay if an employee has a bona fide need to care for an individual or child, and up to 10 weeks to care for a child if the employee has been employed for at least 30 calendar days. Small businesses with fewer than 50 employees may qualify for an exception to these sick leave provisions. This clip presentation is intended to be informative only and is not intended to constitute legal advice. Please contact an attorney if you have further questions about your specific situation. Thank you for listening. We hope you found this video helpful.